We are fortunate enough today to have Michael Slocum join us again to talk about copyright and data, the basics for research. Mr. Slocum is the senior member of the law firm Slocum and Boddie, specializing in contract law, legal issues related to clinical, applied, and basic research, corporate issues, intellectual property, and executive estate planning. He has more than 40 years of experience and has represented hospital systems, hundreds of business, both in the US and non-US, universities, nonprofit organizations, and even agencies of the federal government. Mr. Slocum negotiates clinical and other research contract terms with drug companies and other entities on a daily basis. Mr. Slocum began private practice with his own law firm in 1980. He is an honor graduate of DePaul University and received a JD with honors from George Washington University National Law Center. He is a member of the Virginia State Bar. He is a distinguished faculty member of the Society of Research Administrators and an adjunct professor in the Graduate School of Nursing at the Uniformed Services University of Health Sciences. Please join me in welcoming Michael.
Thank you very much. As Jeff said, I've been involved with research for a long time, and one of the other things that I do is I'm one of the track chairs for the SRA conferences. The copyright program that we're about to do today is what we as track chairs call an evergreen. We try and do it every national conference and most regional conferences as well, because in research, while we all think about, oh, what happens if you get a patent? By far the more common result of research is a copyright. You get a publication, you get presentations, and those things are covered by copyright. And the copyright is protecting the product of the research institution. So the copyright process is just enough different from the patent process that it can be very confusing to those of us who are not daily workers in the intellectual property field. So let's go to the next slide. Okay, what is it we're doing with copyright? First of all, we're protecting works. That is a term of art in the copyright law. A work is one of a long list of things that are protectable by copyright as opposed to patent, trademark, or some other intellectual property law legal concept. It also determines, the copyright law determines who in fact is the author, who is the initial owner, the preparer or developer of the work. And also then, if in the absence of agreement by the people who are involved, it'll also determine who gets to be the author. Then it provides a method for protection of your rights as an owner, and as whether you're the author or a subsequent owner. And then it provides the framework for dealing with the fact that copyright, unlike a lot of other things, can exist at the same time for two different people in the same product. Okay, next slide. That's a derivative. Go ahead. Okay, so first of all, what's protected? Literary, and no matter how dry, no matter how boring, that scientific product is a literary work. It also then protects, but we're not going to cover musical, dramatic, choreographic, pictorial, or graphic, audiovisual, and architectural works. Those will seldom, if ever, be scientific works. The copyright then gives the owner a set of rights, and they're very specific rights. Those include the right to reproduce and to prepare derivative works. Those are things we're going to come back to. The copyright law also decides when do we have a work that can in fact be copywritten, and it defines whether or not a work is original enough to be copyrightable. All right. If you are interested in doing a deeper dive, this article that's referenced, even though it's now 12 years old coming on, is an excellent, slightly more than basic article on copyright. Next slide. Let's do the next slide. Thank you. Okay. First of all, the copyright vests in the author of the work. When we get over into patents, we talk about the inventor of the invention, and deal with that. Here we're talking about the author. That is the person who develops the work. That author can transfer the copyright to anybody else, but they are the initial owners, and they then have, as I say, this series of rights: reproduction, creation of derivative works, distribution of copies, and then display. All right, next slide. All right. Part of the problem we run into, however, when we start talking about research works, is that the research itself can take multiple forms. So a scholarly work might be implemented by a software program, or the scholarly work could actually be displayed or reproduced through software. And at that point, we begin to get into issues of, is that a different work, a derivative work, patentable versus copyrightable, and so forth. All right, we have this thing called work for hire. All right, and work for hire is a very specific doctrine we're going to talk about more, and that will transfer who is the author of the work from the actual person to their employer by law. We'll come back to that. Other issues come about, and particularly in scholarly work, nowadays, most works, if not all, are the subject of collaborations, either between institutions, with a professor and students, or postdocs, or other research collaborators within the institution who may or may not be employees. And then issues of consultants and their contribution and how they come in. And I say consultants in very broad terms: someone who's not an employee, but who is working under some type of a contract. And then non-faculty employees. And this is particularly important because most, if not all, universities have a sharing policy that determines how copyrights and other intellectual property rights are distributed between the employees and the institution. Those policies often don't cover non-faculty employees. And then we find, oops, a non-faculty employee has in fact made an authorship level contribution. How do we deal with that? All right, next slide. Okay. It's important to recognize that joint copyright is not based on percentage of effort or how important your effort is, or did you do the better part of the work or the less part of the work. If you contribute any portion beyond what the lawyers call de minimis, so anything that's more than just a jot or a tittle, and there was any intent at the time that the contributors be joint contributors, then we have joint copyright holders. Even though, again, you may have only contributed 10%, if there is a determination or an intention that you be a contributor, then you are a equal co-owner. And when I say equal, many people think about equal being 50-50. That's not the case. As with many things that are joint, you actually have an equal right to 100% of the whole. So if you wrote 10% of the book, that doesn't mean that you are now, because you're joint, 50% of the book is yours. No, you have the same rights that someone who wrote the other 90% of the book has. That is 100% of those rights. The only right you don't get is the right to do exclusive licenses, because obviously there are joint owners. All right. So now keep in mind, the rules we're talking about are ownership rights. Attribution, so who's the lead author or who is to be listed first, second, third, and fourth on the JAMA or New England Journal of Medicine listing, those are different issues. All right, next slide. Okay, copyright is something that's limited by time, but the law continues to change, and it may change again. In the United States, we have what's called the Mickey Mouse rule. And it's not because it's not important, it's because it's all based on Disney. Mickey Mouse was first published in 1923, and we keep getting changes so that the Mickey Mouse cartoons continue to be under copyright. We may see that change this most recent round because it's coming up, and those cartoons may finally fall out of copyright protection if Disney's not able to get yet another extension on the rules. Now, the rules are reasonably complex in the sense that if you are an individual author owner, you get life plus, right? If you are a corporate author, that is, it's a work for hire, you get a specific period of time. So what I would suggest is, if you're looking at older works, go to the Copyright Information Center, look at your particular work, and fit it within the charts that the good folks at Cornell have done for us in terms of determining how long your copyright is. All right, next slide. Okay, some things that can't be copyrighted. Facts, that's the most important thing in scientific work. The math of a math scholarly work cannot be copyrighted. The math of an algorithm cannot be copyrighted. Recipes cannot be copyrighted for evolutionary reasons, if you want to put it that way. There's no particular reason why recipes shouldn't be copyrightable, but they are excluded by law. The alphabet of any sort cannot be copyrighted, but that's not to say that fonts can be copyrighted. So Times Roman is a copyrighted font. Arial, Calibri, these are all copyrighted fonts, but the letters underlying those fonts can't be copyrighted. Okay? Grammatical tropes, and the example I give is I before E except after C, but one I just ran into was the I love, and then you put something else after that, and the Copyright Office fought me to the death on that, and I lost. So I was not able to copyright a particular phrase with the I love and then or the I heart, if you want to put it that way, phrase. And then the idea cannot be copyrighted. You must fix it in a tangible medium. But how long does the tangible medium have to last? It can be anything that is determinable in time. So anything that's not truly in that theoretically instantaneous form. So if it in a very famous case, the actual copyrightable work existed for only pieces of a second, and that was enough. All right, next slide. All right, you'll see, particularly in contracts with European or Canadian or South American, basically any country except the United States, you'll routinely see language in your contract that's talking about moral rights. Moral rights are a series of rights in addition to the normal copyright that go to the individual's rights in works. They may or may not be the author because of the work for hire doctrine. They may or may not be the owner because they may have transferred their rights, but the moral rights they either maintain unless they separately give them up, or in some countries, they can't give them up. They are automatically maintained by the initial writer, putter together of the work. The right of attribution, that is, who gets to say, I'm one of the authors, I'm the person who did this work to start with. That's a right of attribution. The right to be anonymous or pseudonymous, I can never pronounce that word, pseudonymous. That is a right that in many countries does exist as a moral right. And then the so-called right to the integrity of the work. So if you don't have moral rights, then I could take apart and your particular work and redo it once I have the right to do derivative works or to otherwise modify your work in one way or another. Maybe through fair use, it may be through a contract right, it may be through statutory rights. But if you still have moral rights under the various European or other laws, then you as the original author could say, no, you can't take my work and take it apart and sample it, for example. In the United States, we have sampling by rap and other musical artists in particular. That right is restricted in most of the rest of the world beyond the level that it's restricted in the United States. Now, for films and other visual works only, then in the United States, there's a separate code section dealing with what would otherwise be moral rights in other countries. But those moral rights in the United States do not apply except to visual works. Next slide. Okay. It's important now as you think about copyright to recognize that when we start talking about ownership, we're more in an analogous situation to biology than we are to chemistry. And what do I mean by that? If you have a particular product, a pound of gold, all right, and I say, okay, I'm going to give you half of that, we both have a half a pound of gold, and there's no way that either of us can have more than that. I've given you my half, the half of what I had, and that's all we've got. However, in a biological analogy, then we can have multiple ownerships in the same thing. If I have a cell line and I give you a couple of cells out of that and we both grow the cell lines, now we can both have a pound of the cells and once they grow. So that in patents, okay, once I've given you those patent rights, okay, I've transferred a right to you and it's gone unless I've kept those through some kind of a grant back. But if I have a copyrighted work and I give you a license, in many cases, we both have rights in that same work. For example, and this is an actual case, I had a client who actually went to this. If the original author gives you right to translate the work into, and in the case that I dealt with, it was a translating an accounting textbook into Russian. And the original copyright owner did not take any kind of a grant back. And so the original copyright owner had the right to translate his own work into Russian. And now my client had the right to translate that same work into Russian. And today, that accounting book is on sale in Moscow by both publishers, by both authors in this case. My client was the author of the derivative work to translate the accounting book. And once the original author saw that, they did the same thing and put it out in competition. So copyrights, you need to deal with the fact that you can generate multiple owners of essentially the same item. Okay, next slide. All right, and that's what the whole idea of derivative work is all about. I can take your work, or I can take my own work, and I can turn it into another work. I can do that by translating it. I can do that in music by arranging or making recordings. I can take a factual situation, a factual book even, and dramatize it or fictionalize it. I can make motion pictures out of your work. I can do reproduction of art. I can do whether they're lithographs or those kinds of reproductions, or now digital reproductions. That's what the whole idea of this so-called NFT is all about, is setting up a digital reproduction that cannot then be further reproduced without approval, right? And then I can do abridgments, condensations, and so forth. I can then add additional commentary and so forth. That's still a derivative work. So these are all rights that the copyright owner has and can transfer, but they don't have to. All right, next slide. Okay, your instructors, your professors are going to say, oh, but fair use, fair use. Well, fair use is something that does exist for copyright. So it's with a minor exception, would not happen over in patent law. But in copyright, there are lots of times where by law, we've said, okay, you can use someone else's copyrighted materials for limited purposes. And those limits are set out in the code first, but then have been subject to a huge number of court decisions over what is and what is not fair use. And it varies by what are you doing first. If you're an educational institution, you have a greater latitude for fair use as long as you're using them for teaching, research, so forth. Now, if that educational institution is taking someone's copyrighted works and turning it into a money-making movie, that's a different situation. You're not using those within that scope of that fair use. It also depends on the nature of the copyrighted work. If I take a part of a newspaper, an article, a textbook, and use it for educational use, that's much more likely to be accepted as fair use than if I took again, a rap song, say, and wanted to play that as the background music for my lectures. All right. How much are we using? If I take a couple of pages out of a textbook and use those for a class, that's almost certainly to be accepted as fair use at least once or twice. If I keep using it year after year, maybe not. If I take half of your textbook and use it for my class and reproduce copies for all the students, almost certainly not fair use. Right? And then what's the effect in the market for that copyrighted use? So once again, if I'm taking a part of your textbook and using it for my class, and that means that the students won't buy your textbook, you probably have a good claim against me for copyright violation because it's not fair use. Next slide. Okay. Again, Cornell comes to the aid, as does Stanford. There are two university checklists that help us. And so if you have a fair use question, I would suggest, again, go to the Cornell checklist. And if it is dealing with software or computer materials of any sort, go to the cyber law checklist at Stanford. And once again, this is not the same thing as doing attribution or citation. An example would be, even if I cite your materials every time if I'm simply picking up and copying your materials and then saying, here's the argument, here's the argument, here's the argument, and not doing my own original work, I probably am going way beyond fair use. The reason I say probably, all of this is very fact dependent, all right? Links, referrals, social media, copies back to the citation, those are not copyright violations. But again, if you start doing a lot of embedded links to commercial materials in your materials, that's a different situation. Okay, next slide. Okay, now you will, to the extent that you get into copyright materials in the current events area, you'll start to see something called transformative use. Now, what is transformative use? There's a lot of transformative use of materials in education and research. Criticisms of other people's copyrighted work almost certainly is transformative use. So now if I take an extended quote even from your materials in order to show that your statements are incorrect or are biased or any other reason I'm criticizing your particular work, even if it's positive, it's to show that you really know what you're talking about. That's not a copyright violation. That's a transformative use, and it is specifically accepted in the statute. If I am taking your words and quoting them at length, not to talk about your words, but to discuss your character or your beliefs, and particularly again to criticize those, that is again transformative use and not a copyright violation. If I take your particular material not to take it for any other purpose, but to prove the fact from what you've said, and that again is not a matter of simply saying, well, this person said this and therefore it's a fact, but if I am actually using your material for factual support, that's not a copyright violation. And then again, if I'm simply summarizing what you've said, that's not a copyright violation. There are some other areas that are specifically protected going all the way up to the Supreme Court. So parodies. So if I take what you have said in all seriousness and use it to make fun of what you've said or of you or of the concepts, that is something that's specifically allowed in law and in the copyright law. If I am using your particular language to evoke the symbolism of what you've said, so particularly in things that are maybe poetic or philosophical, you will see this. If I take again a quote, even an extended quote from your materials in order to talk about how great an artist you are or how terrible an artist you are, these would be accepted. And then again, the various uses that we see in internet and social media particularly, where something has been transformed into a meme, is the hot topic today. Is it or is it not a copyright violation when I take your artistic work or your literary work or some combination and use it as a meme? Okay, next slide. All right, so now I'm the owner, and we'll come back to whether or not I'm the owner because I'm the author, the individual author, or because I'm the work for hire author. But I get the right not only to own this, but to transfer this. And I can transfer this by transferring the entire set of rights, or I can transfer just part of those rights. And once I start slicing and dicing, I can transfer in terms of the amount of rights that I give you, the use that I give you, the market in which you can use those rights, and the time in which you can use those rights. So those are all ways I can slice and dice my transfer rights. All right. So if I transfer exclusive rights to you, then and I do not maintain a right at all, I can actually give away my rights so I don't have them anymore. I can also then transfer the rights to you exclusively, except I maintain some rights. Now, copyright transfer must be in writing. That's by law. So I can't give you rights except that are legally enforceable, except with a written document. That's normally going to be either an assignment or a license. Those are the two names for the two kinds of agreements. All right. If I give you non-exclusive rights, I do not technically have to have a written agreement. As a practical matter, transfers, even on a non-exclusive basis, are almost always by written agreement. All right. In some cases, of course, copyrights are transferred by operation of law. That's, again, one of those legal words of art, they're called, or terms of art, meaning even though I didn't do it with a written agreement or an unwritten agreement or any kind of agreement, and maybe not even by agreement, I didn't want to transfer them, it can transfer because the law says so. So the easiest example, of course, is if the company goes bankrupt, the copyrights are assets and they transfer to the trustee in bankruptcy as part of the assets of the bankrupt. If I am an employee and I develop a work, then under US law, by operation of law, I'm not the author, my employer is, as long as it's within the scope of my employment. If I die and I have a copyright, then the copyrights transfer like other assets, either by will or by intestate succession or as part of a trust succession or so forth. All right. And then a copyright is considered personal property. So when you start looking at the general laws of a state that involve ownership of personal property, contracts for personal property, transfers of personal property, those state laws apply, and for that matter, any federal laws, but most personal property right laws are states. Next slide. Okay, again, contract, all right. If you are transferring some but not all the right, it's usually a license. If you're transferring everything, it's an assignment. If you're doing transfer of all the rights, but only for a limited period of time, it's still normally an assignment. But the title you put on something is not nearly as important as the actual words you use. So if you are transferring essentially permanently, completely, then it's going to be more in the nature of an assignment. If it is a transfer just for use or for a limited period of time or limited markets or for limited activities, it's almost certainly more in the nature of a license. And again, licenses have lots of ways you can slice and dice. Those are shown at the bottom: exclusive, non-exclusive, time, geography, the type of media in which you can use it, and then almost any other aspect you can imagine. All right, next slide. All right, so we talk about express licenses. Express does not mean fast. Express means we've written it down, all right? And then you can also have an implied license. So if you have transferred a product that uses copyrighted materials as part of the product, you may be doing a transfer, a license that's an implied license, because those copyrighted materials are necessarily a part of what the product is, right? In certain areas, you have compulsory licenses. And in the United States, there's a compulsory licensing scheme, for example, for music used in most commercial establishments. So if some bar or restaurant is running TVs, jukebox, anything like that, there are compulsory licenses for those displays of copyrighted works. And those bars and restaurants have to pay fees based on schedules that a group, a quasi-government group comes up with on a regular multi-year basis, all right? You also then have things called Creative Commons or other licenses, which this is something that was developed in connection with what's called the open software movement in particular. And these are licenses that say anybody can use this, but if you do use this, you have to do A, B, and C. For example, you have to give an attribution. You have to allow other people to use your derivative works under the same creative license. And you just have to look and see what those Creative Commons licenses say. And then again, there are certain activities in which you have mandatory public access to some works. And this would be in particular court cases, for example. While the annotations that Westlaw or other legal publishers use, you can't say, oh, you can't look at a court case or a state statute, state code of laws without paying a copyright fee. And there's some litigation that's happening in this area right now. Okay, next slide. Okay, again, the agreement that your assignment of a copyrighted work has to be recorded to be enforceable. The recordation is at the Copyright Office. Now, you do not have to actually record the original copyright for it to be effective. Copyright becomes effective as soon as the work is developed. The moment it comes into existence, the author, whoever that is, has a copyright. However, you can't sue over that copyright, so it's not an enforceable right until you register the copyright. And if you then want to transfer, you have to have a written document that again is recorded at the Copyright Office. All right, it's very important to determine when that work comes into existence and who owns it at the time it comes into existence, because that is very much a matter that could lead to huge litigation. The biggest case about that, all the way to the Supreme Court, most of us know about because it was a hot topic for the years leading up to the Supreme Court decision, and then it caused almost everybody to at least tinker with their intellectual property clauses in their contract. Stanford v. Roche had a situation where Stanford had an intellectual property policy saying that the professors will grant is the term they used, a copyright, transfer the copyright and the patent rights to Stanford. The particular professor signed another agreement with the company that then Roche bought, which is why they're on there. But that consulting agreement, it was actually a non-disclosure agreement and led to a consulting agreement, but it said that the consultant hereby grants all the intellectual property rights to, again, the company that became Roche. All the way up to the Supreme Court, we thought we were going to be talking about Bayh-Dole and who had this right and big important public policy, and the Supreme Court said no, it comes down to the contract language. The drug company said that the consultant hereby granted rights, and therefore the rights, the minute they came into existence, became the drug companies. Stanford said they will grant. That's a term in the future. So it only happens if you have those rights already. And since the Roche language said that the consultant never got any rights, no rights to give to Stanford. So there was the whole Supreme Court case, all having to do with the specific language of assignment. Okay, next slide. Okay, institutional settings, this is the work for hire. In the United States, if you are an employee, your works are automatically owned by your employer. This is not true in all other countries. In the US and Canada, it's almost always the case. For Canada, it is, with incredibly rare exceptions, the case for the United States. This is it works within the scope of your employment. Now, if you're an employee, but at night you're writing the great American novel, that great American novel is not within the scope of your employment, and normally at least, and it would not come under the work for hire doctrine. All right, the court case here that everybody should go back and look at is the Community for Creative Nonviolence versus Reed. Reed was an artist, produced a work on commission for the Community for Creative Nonviolence. And then the question came, who had the right to make reproductions? Those are derivative works. Reed said he did. The CCNV said they did because they commissioned the work. And the court, again, looked to the statute and said, Reed's not an employee. If he's not an employee, it's not a work for hire. And therefore, unless it was in the specific contract that he assigned those rights, he kept them. So next slide. Okay, now, normally, while you don't have to have the work for hire doctrine in writing in almost all institutions, and as far as I know, every university, it's in writing. It's in, not necessarily in an individual contract, but it's probably in the institutional policies and procedures. It may also be in your individual or your employee manual or your individual contract, okay? Now, non-employees are not covered. That includes consultants, students, all right, volunteers, anybody like that, patients, subjects. None of those people are covered under the work for hire doctrine. So you will need to deal with that in university policies and with individual agreements with those other non-employee persons, all right? There's then, for teachers, there's something called the Teach Act. And I just point that out. It really does not have much to do with the research. So go back and look at that. The Teach Act policies must be in writing. What that does is it protects teachers and broadens out, essentially broadens out fair use policy beyond what would be allowable for non-instructors, all right? Okay. Now, once again, you also have to have a publication policy that's different from your authorship or ownership policy. You need the publications policies because JAMA and NEJM and all the other learned journals say so, and your folks won't be able to get their stuff published without being in compliance with the various publications policies. Next slide. Next slide. Please advance it. There we go. Okay. All right. Getting permission. It becomes a real important then that we go get permission. We want to use other people's copyrighted works. And when I say copyrighted works, even if it's not copyrighted, we'll talk about some of the things that can't be copyrighted, like those databases. You still want to get permission for use because there are other ways to protect some of those items. There's a whole list here of ways that you get permission for different kinds of works. It can be difficult for particularly older works. So again, this may not be a big issue if you're in the sciences, but if your folks are doing work in anthropology or sociology or the humanities, one sort or another, and you're dealing with old works, it may be very difficult to find who the owners are. I just happened to note, as in passing, some folks in Oh Brother, Where Art Thou, the movie and the soundtrack. They went back and found the original convict chain gang person who was the author of a song that they used and actually paid him royalties, even though he didn't have the right to. But that was an incredible amount of work to find that person. Next slide. All right, some things that you should be looking at right now, and the first sale doctrine is particularly hot and will continue to be hot. And what is that? When you buy a book, you don't own the copyright, but you own the book. But when we start talking about digital materials, a lot of companies now are saying, oh, we didn't sell you the book, the electronic book, we gave you a license in the book. When Tesla sells their cars, there's a huge amount of software, but they're saying you don't own even the software that is installed in your car. You only have a license to that software, and so we can turn it off, among other things, and they have. So the first sale doctrine is something that you want to do, and it's beyond the basics, but it's something that you want to start looking at in terms of what that means, particularly, again, with your questionnaires, with some software that you may or may not actually own, you only have a license in, and so forth. The Digital Millennial Copyright Act is a law that is meant to protect copyright holders. It is often being used right now to knock people out of being able to change software again and to make improvements. So this is an area, again, it's beyond the basics, but take a look at some of the issues there. There's a good article on that. And then fair use will always be an issue. Next slide. Okay, now, those of you who may or may not deal in copyright, if you're dealing with the federal government in particular, you're dealing with data, and data is not exactly the same as a copyrighted work. Data is defined in the FAR and the DFARS, and note it is differently defined. So there is information that is data under the FAR software that is not data under the DFARS. What's the DFARS? The Defense FAR Supplement. But this is an area where they actually have a completely different definition of what's data. Next slide. Next slide. Thank you. Okay, so the data clauses, which are mandatory clauses, which means for those of you in the government contract and grant area, they are what are called Christian clauses, and they will be in your contract if they should be in your contract, even if the contracting or grant officer did not put them in. So this is an area, and this again goes way beyond contract in copyright, but it's something that you should go back and take a look at. The Christian doctrine has nothing to do with religion. It has to do with the court case that originally came up with this doctrine. And Christian clauses are in your contract or grant, even if they're not actually there, because they're required by law to be there. In any case, the data clauses are Christian clauses in many cases. And so you will need to know what those clauses say, and they vary by the type of contract. And they deal with different kinds of data depending on whether it's a research contract, a contract that deals with controlled or classified data, and other kinds of issues that arise. So the data issue is, again, beyond the basics here to some extent, but it needs to be covered because most of us are dealing with, whether it's NIH or DOD or Department of Transportation, we're dealing with government contracts and grants every day. Next slide. Okay. In the grants area, again, often you do not see the data clauses as clearly as you do in government contracts, but the requirements of those clauses are in many cases very similar and are implied or included by operation of law again, right? Now, beyond the issue in US government contracts, you need to recognize that you've got the same issues when you go anywhere else around the world. There's a very, very large law firm that does a very nice job, and I probably need to update that site because they do update the handbook. But DLI Piper, the law firm, puts out a data handbook, and I would suggest you take a look at that, depending on which countries you're dealing in. It's also important when you start dealing in data and other intellectual property rights to recognize that the US government and foreign governments often have MOUs, or memorandum of understanding, that may apply or not apply the intellectual property laws in the United States to foreign grants and contracts. I represent some folks overseas, and one of the first things I had to do was to go see whether or not the Bayh-Dole Act applied to Australian universities. It turns out it does, for at least the ones that I'm dealing with. And so that's a very, very important issue as you start dealing internationally. All right. And then next slide, please. Okay. The last few minutes here, we'll talk about something. Okay. You've got something that can't be copyrighted. For example, a database of a fact compendium of some sort. So since it's facts, it can't be copyrighted. Or an algorithm, again, a mathematical formula, it's what an algorithm is, can't be copyrighted. How do we protect that? And the answer is trade secrets. Now, a lot of universities say, oh, no, we don't deal with trade secrets. Well, yes, you do, all the time. First of all, your information in your proposal, until your proposal is accepted and becomes public, is private. If it's not private, you are running the risk that you are going to lose your intellectual property rights because you made them public. And at least on the patent side, once you've made something public that is inventable, that is patentable, that is in fact the starting point for your patent clock. And you've got it, even though you're the inventor, you've only got 1 year. All right. The trade secret law started out as common law, meaning there was not a statute. However, there is now something called the Uniform Trade Secrets Act in the United States. That is not a federal law. That is a model law that 50 states have passed in one way or another. And so you will need to go to your state law to talk about trade secrets. The federal Protection of Trade Secrets Act has imported some of those things into federal law as well. Okay, what is a trade secret? It's something that by agreement you are keeping secret. That's the basic definition. That's a real general definition. Next slide. Okay, we talked about the Uniform Trade Secrets Act, and again, they have a definition, information that is of some economic value and that you as the owner, the original owner, have tried to maintain it as secret. Okay, next slide. Okay. There is then internationally an organization that covers these issues. That is the World Trade Organization and the World Intellectual Property Organization. So WTO and WIPO, between them, cover intellectual property in terms of multinational laws, treaty, agreement. There are various levels of protection here. So going from a treaty to other multinational agreements to bilateral agreements or agreements within certain areas. So the Europeans have agreements, the Asians have agreements, and so forth. When you start talking international, this gets very complicated, way beyond the basics. So again, I would suggest at that point, get to counsel and get expert advice. And I think we're close to the end. Next slide. Yeah, so I know we only have a few minutes, but obviously I'm perfectly happy to take questions, and I can take them as long as they leave the meeting open. So Jeff, back to you. Okay.
And we have our first question in the chat. What are the hot topics going 5-10 years into the future?
5 to 10 years in the future. Okay, the very first one, and this is, you're asking, I'm a big science fiction fan, okay? So I'm going to tell you the very biggest issue is going to be works generated by artificial intelligence entities, whatever those may be. Because artificial intelligence, by definition, can now generate works. And in fact, they have. They've generated artworks, they've generated other visual works, short movies so far, and could go beyond that. At which point, who owns that? Is it the people who developed the AI? Or is it the people who ran the AI? Or is it the people who put the inputs into the AI? Or is it some combination of that? So there's and that is, I'm quite serious, that is going to be a major, major issue. Again, transformative works, particularly as we get into what the Facebook people are now, it's Meta, and that's what it's all about. The works developed in the so-called metaverse, and who owns those? The whole concept of NFTs, which is, I can't ever remember what that acronym stands for, but essentially it's restricted transfer digital works. Those of you, any of you who are gamers or anything like that may know, people do tokens and they do avatars, and I'm not a gamer, so I only know this from, again, reading my science fiction books. But who owns those avatars and who can control those? And what about derivative works from those and so forth? Any of you who are into cosplay know that all those uniforms, so to speak, are derivative. And again, those are all copyrightable works, even though they're in fabric. But lots of art is done in fabric. Or the equivalent, plastic or whatever it may be. Similarly, the intersection between patentability and copyright is going to be a continuing big issue, especially as we get into the equivalent of 3D printing in all kinds of products, and even more so the whole development of biological materials through the next step from CRISPR, where you're actually generating a new biological stuff from a series of instructions given to a molecule to develop more stuff. Those instructions, at least arguably, are a copyrightable work. Or are they? Are they facts? Or are they from the non-patentability side? Are they natural activities that can't be patented either? Lots of issues there in that intersection between copyright and patent that are going to be coming. And then the international ownership of particularly, again, those instructional works that lead to the ability to develop new medicines, new products, new social good activities. And especially as we get to the point where you can, again, I use just the real broadly, that whole idea of 3D printing or of generation by a set of instructions given to a machine that then in turn develops a new thing or work or whatever, or some combination of that. That is really going to be a major area for new legal innovations as to ownership. So it's kind of an exciting thing if you're into where this could all be going. So if you got any law school professors, this is something to start writing articles about today. So they are actually. Other questions?
I don't have any other questions in the chat.
Okay. If you are into this, just Google that whole idea of copyright by AI, and you'll find some interesting stuff going on there. So,
well, thank you so much, Michael. The case studies, the information, very engaging. We really appreciate your time this afternoon.
Thank you, and thank you for all of you who decided to take your Friday afternoon for this stuff. And those of you on the East Coast, at least the Northeast, be careful driving tonight. Apparently, it's going to be a big storm coming. So, thank you very much.
Thank you.
Okay.